Hi, my name is Chaturvedi and I am a legal intern at LEXIS and Company. So today we are going to talk about civil law and common law. Common law system. Countries following a common law system are typically those that were former British colonies or protectorates, including the United States. Features of a common law system include there is no always a written constitution or codified laws. Judicial decisions are binding. Decisions of the highest court can generally only be overturned by the same court or through legislation. Generally, everything is permitted that is not expressly prohibited by law. A common law system is less prescriptive than a civil law system. A government may therefore wish to enrich protections of its citizens in specific legislation related to infrastructure program being contemplated. For example, it may wish to prohibit the services provider from cutting off the water or electricity supply of bad players, or may require that documents related to the transaction be disclosed under a Freedom of Information Act. There are few provisions implied into a contract under the common law system. It is therefore important to set out all the terms governing the relationships between the parties to a contract in the contract itself. This will often result in a contract being longer than one in a civil law country. Civil law system. Countries following a civil law system are typically those that were former French, Dutch, German, Spanish, or Portuguese colonies or protectorates, including much of Central and South America. Most of the Central and Eastern European and Eastern Asian countries are also follow a civil law structure. The civil law system is a codified system of law. It takes its origin from Roman law. Feature of a civil law system include there is generally a written constitution based on specific codes, enriching basic rights and duties. Administrative law is, however, usually less codified, and administrative court judges tend to behave more like common law judges. Only legislative enactments are considered binding for all. There is a little scope for judgment made law in civil, criminal, and commercial courts, although in practice judges tend to follow previous judicial decisions. Constitutional and administrative courts can nullify laws and regulations, and their decisions in such cases are binding for all. In some civil law systems, example Germany, writings of legal scholars have significant influence on the courts. Courts specify to underlying courts. There are therefore usually separate constitutional court, administrative court, and civil court systems that opine on consistency of legislation and administrative acts with and interpret that specific code. Less freedom on contract. Many provisions are implied into a contract by law, and parties cannot contract out of certain provisions. Nationality and domicile. Nationality, as the name suggests, is something in connection with the nation, which a person obtains by birth and is innate. On the other hand, citizenship is a bit different, which require a person to fulfill the legal formalities to become a recognized member of the state. Difference between nationality and citizenship. In nationality denotes where an individual has been born or holds citizenship with the state. Nationality is obtained through inheritance from his or her parents. It's ethnic or racial, the place or country where the individual has taken birth. Whereas citizenship is a legal status in a political institution such as a city or state. The legal relationship between a citizen and the constitution that confers this status is formal. Legal or juristic, the individual is designated as a citizen by the government of the country. Birth, inheritance, marriage, naturalization. Thank you.